Court does call the case of the people of the state of Michigan versus James Percy.
On behalf of the people.
This case opens with a controlled courtroom tone, but beneath it sits a volatile allegation, one that involves physical confrontation, a weapon, and an interrupted emergency call. The prosecution is about to build a narrative that frames this as a serious criminal incident, not just a domestic argument gone wrong. And when you hear charges like assault with a dangerous weapon and interference with communication, you're dealing with offenses that courts take extremely seriously. Right now, the judge, Judge Simpson, is setting the procedural foundation. Names are being recorded, roles are being clarified, and everything is being locked into the official record. This may seem routine, but it's critical. Every word from this point forward becomes part of the legal timeline. Now understand the strategy. The prosecution will aim to present a clean, consistent story, one where the defendant's actions escalate into criminal conduct. The defense, on the other hand, will look for gaps, contradictions, and anything that introduces doubt. This is not just about what happened, it's about what can be proven. And as this unfolds, every detail, every pause, every correction will matter. Because in court, certainty wins cases, and uncertainty can break them.
Good afternoon, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Percy. Mr. Percy, please state your name for the record.
James Percy, Jr.
All right. Date and time set for preliminary examination. Ready to proceed.
The people are ready to proceed. Yes.
All right. You may proceed.
The people will call Margaret to the stand.
Ma'am, if you can come forward and be sworn. Please face me, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God? All right. Please have a seat. Upon having a seat, please state and spell your name for the record.
Margaret Beverly King, Margart, Beverly B-R-L-Y, King, K-I-N-G.
You may inquire.
Do you recall July 10th, 2023?
Yes.
Where were you?
At my apartment.
And what is the street address of your apartment? Do you know what city or township that is in?
Yes, that's Ann Arbor, Michigan, Washington County.
And who were you with that day?
Yeah, 5 James Percy.
And do you see Mr. Percy in the courtroom? Can you please point him out and tell me something he is wearing? Thank you. Let the record reflect that the witness has identified the defendant as James Percy.
The identification is now official. The witness has pointed out James Percy in court, and that ties every allegation directly to him. There's no ambiguity left about who is being accused. From here on, the focus shifts entirely to credibility and consistency. The prosecution immediately reinforces the relationship. 9 years. That's not just background information. That's context. A long-term relationship introduces emotional complexity, history, and potential patterns of behavior. It can strengthen the prosecution's case by suggesting familiarity and recognition, but it also gives the defense room to argue bias, resentment, or personal conflict. Now think about this. When someone accuses a person they've known for nearly a decade, does that make the testimony more reliable or more emotionally influenced? That's exactly the kind of question the defense wants sitting in the minds of anyone evaluating this case. At this stage, the groundwork is being laid carefully. Identity confirmed, relationship established. Now the courtroom is ready to move into the actual events, and whether that story remains consistent under pressure.
Record shall so reflect without objection.
And what is your relationship with the defendant?
We've dated on and off for 9 years.
And what happened on July 10th, 2023?
Well, we had come in from a psychiatrist appointment and got half of a gallon of Jim Beam.
Objection, Your Honor. Foundation.
Sustained.
And that was all that was remaining in the bottle.
Well, no, I've sustained the objection. Ask your next question. Court will disregard what was said.
Okay. And did you get into an altercation with the defendant?
Yes, I did.
Was this a physical altercation?
Yes, he pushed me.
And when you say he pushed you, can you demonstrate how he pushed you?
He pushed me. I was getting into the bed and he pushed me off the bed. And I fell back and I hit my head on my shoulder. I didn't hit my head.
And for the record, that was 2 hands to push you?
Yes.
And did you give the defendant permission to touch you?
No.
And what happened after that?
After that, I grabbed my phone and I tried to call 911. The battery was low. He asked me if I was calling the police. I said yes. He rushed around the side of the bed, grabbed the phone away from me. I then got up, got his phone, had to put it in him, tried to use his phone to call 911. Before I could get a call off.
I'm going to stop you. I'm going to stop you right there for a second. When he took your phone the first time, were you able to call 911?
No, I wasn't able to hit send before he got it out of my hand.
And did you give the defendant permission to touch your phone?
No,
And then you said you went into the kitchen. What happened?
I had grabbed his phone, tried to use his phone to call 911. He had a special lock on his phone. I couldn't crack it. By the time I was trying to get a 911 call off the kitchen, and got that phone away from me.
Okay, so you weren't able to call 911 that time. And then what happened?
Then he reached into the butcher block, pulled out a knife, held it over my head, said, bitch, if you say one more word, I'm going to decapitate you.
This is the moment the case escalates dramatically. A direct threat involving lethal violence combined with the presence of a knife changes everything. This is no longer just about physical contact, it's about perceived life-threatening danger. Legally, the focus here is not whether the act was carried out, but whether the threat was credible and immediate. The witness describes the defendant standing roughly 2.5 feet away. That proximity matters. That's close enough to act instantly, which strengthens the prosecution's argument that the threat was real and imminent. The wording of the threat is also critical. Specific, violent language carries more weight than vague statements. It suggests intent, or at the very least, the appearance of intent. But here's where the defense will push back. Was this a serious threat? Or an emotional outburst? Was it exaggerated in retelling? The difference between those interpretations could decide how this moment is judged.
And how far away was he standing when he said this?
From here to here,
I'm sorry, Your Honor.
Can you do that again?
from where I'm sitting to right here.
Okay. Record to reflect that's about 2.5 feet.
And did the defendant say anything else to you when he held the knife?
Say one more word, I'm going to decapitate you. And then we get a little bit of a stare down. After that, I grabbed the block that he had grabbed the knife from, and I grabbed 2 knives. And I held them out and said, well, okay, if you're gonna do some slicing, I will too.
And how did you feel when he threatened you with the knife?
It was very fearful that I didn't want to let him see me sweat, so I did what I felt was necessary to make him feel that I'm as crazy as he is.
May I have a moment, Your Honor?
You may.
And when he got the knife, did he point that at you?
He held it over my head.
So did he come towards you with the knife?
Yeah, yeah.
Objection, Your Honor, please.
Overruled.
No further questions, Your Honor.
Thank you. Cross-examination. You may.
This is where the dynamic shifts. Cross-examination is not about telling a new story. It's about testing the existing one. The defense now has the opportunity to challenge every detail that's been presented so far. Expect a change in tone. The questions will become sharper, more pointed, and sometimes repetitive. That's intentional. Repetition can expose inconsistencies. Slight changes in answers can create doubt. The defense will likely focus on timeline issues, prior interactions, and anything that affects credibility. Because in a case like this, credibility is everything. If the witness's account appears inconsistent, even in small ways, it can weaken the entire prosecution narrative. Now consider this. If parts of the story begin to shift under questioning, does that change how the earlier testimony is perceived? That's exactly the strategy being deployed here.
Thank you, Your Honor.
Mm-hmm.
So, Ms. King, it was your testimony earlier that you and Mr. Percy have been dating off and on for the past 9 years. Is that correct?
Correct.
Would I also be correct in saying that for approximately 6 months before that day in July of this year, that Mr. Percy had been residing with you?
No, not. We would stay sometimes. We did not reside with me. He didn't pay me any money.
Isn't it correct that in actuality, he paid you $400 a month to stay there? And is your testimony?
What is irrelevant to the,
Oh, Your Honor, I was just following up on what she said. But I can,
I'll sustain the objection, move on.
so during the, it was your testimony that Mr. Percy came over after 5 o'clock that day, is that right? Isn't it correct that he had actually been at your home before that, before going to the psychiatrist? And he had actually spent the night from the night before, isn't that correct?
That's correct.
And the two of you had actually been together since even the day before that, is that right?
Objection, Your Honor, relevance.
Overruled, go ahead.
I believe he was around the day before that.
And over the course of these days, you and he had engaged in drinking alcoholic beverages. Is that correct?
No, not.
Objection, Your Honor, relevance.
Well, since she was bringing up alcohol, you objected. Now you want to bring up alcohol?
I would, Your Honor.
You would?
Yes, I would. like
Okay,
to
well, the
control
door's open. I'll overrule the objection. Good luck with that.
And over the course of these 3 days, the two of you have been drinking alcohol. Is that correct?
No, that is not correct. Alcohol wasn't brought into the picture until July 10th.
So would I be correct in stating that over the course of these 3 days that illegal substances were used by both of you? Is that right?
No, that's not correct.
And would I be correct in stating that you, on July 10th, had smoked crack cocaine with Mr. Percy?
Objection, Your Honor, relevance.
What is the relevance in this?
Now the defense introduces a critical tactic, attacking credibility through substance use. This is a high-risk, high-impact strategy. By bringing up drug use, the defense is attempting to suggest that the witness's perception, memory, or judgment may have been impaired. Notice how the prosecution immediately objects. That's because relevance is key in court. You can't just introduce damaging information unless it directly connects to the case. But here, the defense argues that it goes to credibility and motive, suggesting that the events may have been influenced by drug-related circumstances. The judge allows limited exploration of this line of questioning, which is significant. It means the court sees potential relevance. Now the question becomes, does this information genuinely affect the reliability of the witness's testimony? Or is it simply an attempt to discredit her character? That distinction will play a major role in how this testimony is evaluated.
Your Honor, Mr. Percy is indicating that Miss King's testimony and initial call were motivated by a situation with the substance use and a drug dealer. And so it's going to credibility.
I'll allow a little bit of an objection to overrule. Go ahead.
That day, one hit of crack cocaine that I did.
And over the course of that day, there was even a period of time where your drug dealer was actually in your home, correct?
No.
Objection, Your Honor, relevance.
What is the relevance of whether her dealer was there? Presuming she has one.
Again, Mr. Percy is indicating that the situation and the phone call by Miss King are not true and were actually motivated by the situation between Miss King and her drug dealer.
Are you saying the drug dealer pushed her off the bed?
This is a strategic pivot by the defense. Instead of directly denying the allegations, they introduce an alternative explanation, suggesting that other individuals or circumstances may have contributed to what happened. By bringing up a third party, a drug dealer, the defense is planting doubt. They're essentially saying, what if this isn't the full story? Even if the alternative explanation isn't fully proven, its presence alone can create uncertainty. The judge allows some of this questioning but also keeps it controlled. That balance is important. The court wants relevant information but not speculation that could mislead. Now analyze this carefully. If there are multiple possible explanations for the same event, which one seems more consistent with the evidence? That's the exact dilemma being introduced here.
Your Honor, he is denying that, but he is saying that there were other circumstances that resulted in these false accusations.
I'm not following. He's saying there are other circumstances that resulted in her
False.
making these claims against him.
That is correct.
Okay, I'll let you go. I'll overrule it. Let's hear it.
Thank you, Your Honor. So I think I'm going to repeat a question that I asked you just because I want to make sure that I didn't skip it, okay? Isn't it correct that your drug dealer had been over there with you and Mr. Percy at one point during that day? Isn't it correct that a gentleman named Mo had been there with the two of you that day? And during the course of this day, Your Honor, may I have one moment, please?
Yes.
And would I be correct in stating that Mo was there the day before, right? And that he was there the day before, July 8th? In fact, he spent a considerable amount of time at your home.
Sustained.
Now, before Mr. Percy went to his psychiatrist appointment, would I be correct in stating that you and he had gone to Family Dollar?
Your Honor, relevance.
What is the relevance of this? I mean,
I,
they did something during the day, apparently.
Your Honor, I anticipate that Ms. King will be denying these things, but again, these are the things that Mr. Percy is stating.
I'll sustain, I understand. I'll sustain the objection.
Isn't it correct that Mo took you and Mr. Percy to Dollar Tree that day?
Sustained.
And in fact, over the course of that day, the two of you were shoplifting for money for drugs.
Sustained. All right, I'll wait for you to get it out next time.
Okay. Now, when Mr. Percy returned home, by that time, Mo had left, isn't that correct?
He was never there.
However, at that time, you had also decided that Mr. Percy, you didn't no longer wish Mr. Percy to reside with you, is that correct?
I never wanted Mr. Percy to reside with me. I allowed him to stay the night several times, but I never allowed him to move in with me. I never collected any money for rent. He made me about out of house and home.
And it was
5 meals a day.
when,
Go ahead.
thank you. And at that time is when you decided to call law enforcement, correct?
I decided to call law enforcement. I couldn't get out of bed. I couldn't get a phone call because my battery was low. I called.
So it's your testimony that you could not get that you were, because your battery was low, you were unable to get a phone call.
Objection, Your Honor, should let the witness fully answer the question. I think we could have heard the answer to the question. Her testimony earlier was that she tried to call, her battery was low, and he came around the bed and grabbed the phone. So if we could have the witness answer the full question.
Marie was doing just fine.
I'm gonna
Overruled.
hold it in, but-
Overruled. You're welcome. Go ahead, Ms. Gaines.
Thank you, Your Honor. So it's your testimony that your battery was low and you were unable to make the call on the phone?
Before he grabbed it, yes.
Yep.
The defense now targets a technical detail, the phone battery. This might seem minor, but in legal terms, it's crucial. The prosecution claims the defendant interfered with a 911 call. The defense is questioning whether that call could have been made at all. If the phone battery was critically low, the defense can argue that the inability to call wasn't caused by the defendant. It was due to the device itself. That weakens the interference charge. But listen to the witness's response. She claims there was just enough battery to attempt the call. That keeps the prosecution's argument alive. This is a classic courtroom battle over detail. Small technical facts can have large legal consequences. Now consider this. Does the explanation about the battery feel consistent, or does it raise more questions? That's exactly what the court must determine.
Are you also indicating that you would not have been able to make the call because of your battery?
I had just enough to probably get the phone call off, like 3 or 4%. And then when I did get the phone call off, was after I was able to get a little bit of charge on the battery after he had pulled the knife on me, told me he was going to decapitate me. I take that very seriously when someone says they're going to kill me. And they've said it before. And they've said things like, I've thought about it, and I will kill you, and I will kill you before the police can even get you.
This segment intensifies the emotional and legal stakes significantly. The witness introduces prior threats, suggesting this wasn't an isolated incident but part of a pattern. In court, prior statements like this can be powerful, but they also come with strict scrutiny. The defense immediately targets a critical issue. Why wasn't this disclosed earlier to law enforcement? That's a major credibility checkpoint. If someone claims repeated threats but failed to mention them during the initial report, it raises questions. Was it forgotten, omitted intentionally, or added later to strengthen the case? These are exactly the angles the defense will exploit. At the same time, the content of the threat itself is severe. Statements implying intent to kill before police arrival suggest urgency and danger. If believed, this reinforces the prosecution's argument about fear and imminent harm. Now analyze the tension here. Does the late introduction of prior threats weaken the testimony, or does it simply reflect the chaotic nature of traumatic events? That distinction will heavily influence how this moment is interpreted.
Would I be correct in stating that that is information that you did not disclose to law enforcement on July 10th of this year? That there have been prior threats?
All I told them there was going to be fire.
Would I be, so I want to go back to something you just said. So you indicated that there was a point where you were able to get your charger, get your phone, and plug them in. Is that correct?
Correct.
And you had it, and you were able to have the charger on for a period of time where you were able to get more than 3 or 4%. Is that your testimony? I want to make sure I understand.
Not much more, a short period of time. I had told him to go to bed after he put down the knife and put down my phone so that I could put it on the charger. But he wouldn't go to bed. He kept coming out and taunting me and saying, I can take you. I can take you. And I kept telling him to go to bed, just leave me alone. And he kept coming up on me, and he'd come up with an aggressive manner. So finally, I grabbed the phone off the charger and I called 911.
The narrative now focuses on repeated behavior, movement, persistence, and pressure. The witness describes the defendant going in and out, approaching multiple times, maintaining an aggressive presence. This isn't a single moment. It's an ongoing pattern during the incident. Legally, repetition can strengthen a case. It suggests intent and consistency in behavior rather than a one-time lapse. The prosecution can use this to argue that the defendant's actions were deliberate and sustained. However, the defense will look at the same details differently. They may question the timing, the number of movements, and whether the witness can accurately recall these specifics. Notice how earlier she struggled with exact durations. This is where that uncertainty becomes relevant. The key issue here is reliability. Can the sequence of events be trusted as described? Or does the lack of precise timing introduce doubt? This is where small inconsistencies can start to accumulate. And in a courtroom, accumulation matters.
And I asked to hold on to the phone until they got there. I put a robe on because I was naked, and I went out front to wait for the police because I live in a security building, and he kept saying, before they ever get inside, you're going to be dead.
Ms. King, is it your testimony that you were naked during this whole incident that you described in terms of being on the bed?
Objection, Your Honor, relevance.
She opened the door to it, overruled. Go ahead.
Yes, I was naked when I was getting ready to go to bed. They pushed me off the bed and being chased into the kitchen. I was naked. He was naked.
He was naked?
Yeah.
Now the defense introduces a detail that may seem unusual, but it's highly strategic: nudity during the incident. This isn't random questioning. It's meant to reconstruct the environment and potentially challenge the narrative. Why does this matter? Because context affects perception. If both individuals were in a vulnerable, non-confrontational state, like preparing for bed, the defense may argue that the situation escalated suddenly rather than being premeditated. At the same time, it can also create confusion or discomfort, which sometimes impacts how testimony is perceived. Jurors, or in this case the judge, must process whether this detail supports or contradicts the overall story. The witness maintains consistency, stating both were naked during key moments. That consistency helps her credibility, but it also adds complexity to the scenario. Now consider this. Does this detail make the situation feel more spontaneous, or does it raise more questions about how events unfolded?
Did he come? So are you trying to let us know that after coming from the psychiatrist, at some point he took off his clothes?
Yes. He was falling over drunk.
And it's your testimony still that at this time you had not had anything more than that one hit of crack cocaine earlier that day?
Yes.
No alcohol from.
I did have one glass of alcohol. I made it with coffee and the Jim Beam that he brought in, and cream and sugar. And I milled that through the night.
Okay. Okay. So approximately what time is it? Approximately what time was it when you indicated that you were pushed off the bed?
Timing now becomes the focal point. The defense is narrowing in on the timeline, when the incident started, how long it lasted, and what happened in between. This is a classic credibility test. The witness estimates around 10 p.m., with events stretching back several hours. The defense then probes deeper. What was happening between 5:30 and 10? Drinking, interactions, movement throughout the home. Here's why this matters. A long, unclear timeline creates opportunities for doubt. If events aren't tightly defined, the defense can argue that the sequence may be misremembered or misrepresented. At the same time, the witness provides some consistency, mentioning a single drink over several hours. That detail is being tested against earlier questions about substance use. Now the court is evaluating not just what happened, but when it happened. And in legal cases, timing can be just as important as action.
Approximately 10 o'clock.
Right. And your statement is that from approximately 5:30 until 10 o'clock, you were nursing the one drink?
I didn't start on the one drink until 7 or 8. Because he kept losing the bottle and getting argument about that I stole his liquor.
Okay. So, and during this whole time, you both are naked?
From about 8 o'clock on.
Now you stated, I'm gonna move forward in time to back to where we were when you were talking about the putting the charger and the phone on the charger again. So you stated, so it's your testimony that during that time, Mr. Percy was going in and out of the bedroom? Approximately how many times would you say he went in and out of the bedroom? And during this time, let me rephrase that, I said it backwards. And as he was going back and forth, these 5 to 10 times, approximately how long would you say that lasted?
This is where precision, or lack of it, comes under pressure. The defense repeatedly asks for specific durations, minutes, frequency, exact timing, and the witness struggles to provide clear answers. That hesitation is significant. In court, uncertainty can be interpreted in different ways. It might reflect the stress of the situation, or it might suggest gaps in memory. The defense is methodically narrowing the window. Was it 3 minutes, 10 minutes, longer? Each answer, or lack of one, adds to the overall picture. But here's the critical point. The defense doesn't need exact answers. They just need to show that the timeline isn't solid. If the sequence of events becomes unclear, it weakens the prosecution's ability to present a definitive narrative. Now evaluate this carefully. Does the lack of precise timing undermine the testimony, or is it a natural result of a chaotic situation?
Question.
Approximately how long was he going in and out of the bedroom? 5 to 10 times. Like 2 minutes, 5 minutes, 20 minutes?
Like how many minutes was he out of the room?
How many minutes was the back and forth going? From the bedroom to where you were, from the bedroom to where you were?
I don't recall exactly.
Would I be correct in stating that it was more than 3 minutes?
I would think so.
Would I be correct in saying that it was more than 10 minutes?
I don't think so, because he was on the phone trying to get drugs, calling his drug dealer, Teddy.
So at some point, he stopped going back and forth and he was using the telephone?
Yeah, he was using the telephone, he'd go in and sit down on the bed, and he'd drink some, and then he'd use the bottle behind the blanket or whatnot, and then the next thing I know, he'd be coming out to ask me what I did with his bottle, because I was trying to watch a movie in the living room.
And that, the watching of the movie and the charging of the phone, all of that was occurring at the same time?
No, the charging of the phone and all that didn't start until I tried to go to bed at about 10 o'clock.
The timeline is now being reconstructed in detail. The witness clarifies that key actions, charging the phone, attempting to rest, occurred after the main confrontation. This sequencing is crucial. Why? Because it helps establish cause and effect. If the threat and physical altercation happened first and the phone charging came later, it supports the idea that the witness was reacting to the situation rather than initiating it. The defense, however, is looking for inconsistencies. They're comparing earlier statements with current ones, checking for shifts in order or detail. This is a subtle but powerful strategy. Even small changes in sequence can raise questions about accuracy. Now the court must decide, does this revised timeline strengthen the narrative, or does it introduce doubt?
So I just want to make sure I understand the order of what you were saying. There was the incident that you described. Then
Which incident?
I'm sorry. There was the incident that you described as occurring in the kitchen where you had knives and he had a knife. Is that correct?
He had the knife first, yes.
And after that is when you started watching a movie. Is that right?
No, I had been watching the movie before that. And I think I sat down and started over again because I wasn't comfortable going in and laying down. Wasn't a good time to go to sleep when you've got somebody who just threatened your life.
So it's your testimony that at that time you sat down and started the movie again? Is
I
that
believe I started it again, and I put the phone on the charger in the living room, and I kept the knives handy because he kept coming in and out of the bedroom.
Repetition returns as a key theme. The witness describes multiple entries and exits, reinforcing the idea of ongoing tension rather than a single event. The prosecution can use this to argue persistence and intimidation. Repeated movement towards someone in a threatening context can increase perceived danger. But again, the defense will focus on specifics. How many times? Over what duration? Without clear answers, repetition can lose some of its impact. Still, the overall impression remains. This was not a calm environment. It was unstable, unpredictable, and escalating. Now consider this. Does repeated behavior strengthen the sense of threat, even if exact numbers aren't clear?
okay? So there was some time where you were watching the movie, is that right? After the kitchen. And then there was some time where he was going back and forth. Is that right? And is it your testimony that you continued to have the knives on you?
I had them on the table by me, yes.
And it was only after perhaps the 5th or perhaps the 10th time of Mr. Percy coming out of the bedroom that you decided to call law enforcement. Is that correct?
It was probably after the 5th or 6th time.
This moment connects the timeline to action. The witness explains that the decision to call law enforcement came after multiple instances of aggressive behavior. That sequence is important. It suggests that the call wasn't impulsive. It was a response to repeated escalation. This supports the prosecution's argument that the situation reached a threshold of danger. However, the defense may interpret this differently. Why wait until the 5th or 6th instance? Why not call earlier? These questions aim to challenge the urgency and credibility of the response. This is where interpretation becomes critical. The same action, waiting before calling, can be seen as caution or inconsistency, depending on perspective. Now evaluate this. Does the delay make the response more reasonable or more questionable?
Tell him to just go to bed. But Mr. Percy is very jealous and he's demanding, like, come to bed now. Don't talk on the phone. Put it on speaker.
Was that happening at that time?
At the time that I took the phone call that caused him to push me off the bed, he was telling me to put it on speaker. I hung up the phone, he made me mad, and that's when he pushed me off the bed.
Would I be correct that at that time you were actually talking to a different one of your drug dealers?
Sustained.
Can I have one more here, Mr. Percy? One more question.
Yes, you may.
I believe those are all the questions we have. Thank you.
Thank you. Any redirect?
No further questions, Your Honor. and
Thank
no
you.
further witness.
All right, you may step down. You said you have no further witnesses?
Yes, Your Honor.
All right, you may step down. Thank you, ma'am. Any witnesses for the defense?
No, thank you.
Oh, I'm sorry. No, thank you.
No, it's okay. You didn't have to stand up. You've been up for a while. All right, do I have a motion?
Your Honor, the people would ask the court to bind over on counts 1 and 2, both 3, 4, and 5 following. The people believe they met the probable cause standard for assault with a dangerous weapon and interfering with electronic communications. The victim testified that she got into an argument with the defendant where he pushed her onto the floor, took away her phone when she was attempting to contact the police. The defendant pointed a knife at her and in a threatening manner that made her feel fearful and stated that he would decapitate her. Thank you.
This is the prosecution's summary phase, where all testimony is condensed into key allegations: phone interference, weapon use, and fear. These are the pillars of their case. Notice how concise it becomes. After all the detailed testimony, the argument is distilled into core elements. That's intentional. The court needs a clear, structured understanding of the charges. The defense has already attempted to weaken these points through cross-examination, questioning credibility, timeline, and alternative explanations. Now the judge must evaluate everything presented so far, not in isolation, but as a complete picture. This is the moment where arguments transition into decisions.
Response?
Yes, that the court find that the burden of proof had not been met, not find ultimately.
Court, after hearing all of the testimony, court believes that the people have indeed sustained their burden of showing that the offense of assault with a dangerous weapon or felonious assault has occurred, as well as the interfering with an electronic communication device. Therefore, the court will bind the defendant over on counts 1 and 2 with 3, 4, and 5 following. Ms. Gaines, as to the circuit court arraignment.
Your Honor, we acknowledge receipt of the information, waive its reading on the record, and at this time, Mr. Percy wishes to stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all 5 counts. Pre-trial in this matter will be set for
October 4th at 1:30 p.m. with Judge Conlon.
October 4th, 2023, 1:30 before Judge Conlon. Bond in this case will continue.
The court delivers its decision, and it's decisive. Judge Simpson finds that the prosecution has met its burden of proof for the charges presented, including assault with a dangerous weapon and interference with electronic communication. This doesn't mean a final conviction yet, but it does mean the case moves forward to a higher court. The evidence presented was strong enough to justify continuing the legal process. Now look at the broader implications. Despite challenges to credibility, timeline inconsistencies, and alternative explanations, the court found the core allegations sufficiently supported. This highlights a key legal principle. The burden at this stage is not absolute certainty. It's whether there is enough evidence to proceed. The defendant enters a not guilty plea, which sets the stage for the next phase, where evidence will be examined even more closely. This case demonstrates how complex real-life incidents become when filtered through legal standards. Emotion, memory, and fact all collide, and the court must navigate through all of it to reach a decision. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.